Well, part one, I'm going to come back, Mr. Speaker, to an issue that I signalled, which was puzzling to New Zealand First when we first read this bill yesterday, and it stood out quite glaringly, the proposal to move, or, sorry, I'm just looking for it now, Clause 4, Section 36 Amendment, hearing procedure, which seeks to reduce the numbers of members on the hearing panel from 3 to 2. Going back into the primary legislation, this is dealt with under Clause 136 under hearing procedure there. 1361, at each hearing session, no fewer than 3 members of the hearing panel must be present. This bill, under Part 1, Clause 4, simply replaces the numeral 3 with the numeral 2, which raises some interesting questions, Mr. Chair. The member for the Green Party actually raised one of them. If we end up in a situation where you have 2 people sitting on that hearing panel and there's a disagreement, bearing in mind that under Clause 5, this panel has had its powers amended through the amendment to 144 of the primary legislation, where they are now able, under this legislation, the hearings panel is able to make recommendations on the proposed plan, including any recommended changes to the plan at the end of the hearing of those submissions. If we end up in a position where now, because they can report back in stages and they can make recommendations in stages as opposed to having to wait until the entire hearing process is over, can the Minister tell the House, if at the end of that phase of the hearings, the 2 members sitting there disagree on a recommendation, how do you break that stalemate? See, normally, Minister, anywhere else in the world, people recognise the need to have an odd number so that you can have a debate and someone can adjudicate and there's a casting vote in there. But now we're going to report back in stages. I'm surprised that Mr. David Seymour hasn't raised this matter. Being such a bright lad, he would have picked up on this very, very quickly, no doubt. But reading back into the primary legislation that Part 1 is amending in Clause 4 and 5, we know 2 things now. The rules around the hearings have changed. The members on the panel can report back and make recommendations at the end of a session on a topic. So when they've concluded hearing submissions on that particular topic, and everyone's left the room, and they're sitting and discussing, well, should we put through our recommendations now on that topic? If they both disagree on the weight of the evidence, they have drawn different conclusions, and they disagree, where does the tiebreaker come in? Where? So I'm going to ask the Minister, because it's very important, we're reducing the quorum from 3 to 2. There's also another issue. If you go into a little deeper into the primary legislation, I think you've got to go to 144, and if I might just whip back there briefly and have a look at 144. Hearing panels make recommendations to the council. No, I think it's under a different clause. There's another little issue that pops up. For there to be a hearing, there has to be a chair of that panel. And under the unamended legislation, you had a quorum of 3, and if the chair didn't turn up, the 2 of them could vote for one person to be the chair. Well, now if there's a quorum of 2 and the chair doesn't turn up, where is it in the legislation that says that the other person who did turn up automatically becomes the chair? I don't know. Well, if you don't have a quorum, you don't have a quorum, you can't convene. So I guess the question around the appointment of chairmanship might not be relevant in there, but the question under the rules where you had 3, yeah, it is over the next page. I know I was looking at it, and I thought, well, where does this work? If you have a quorum of 3, coming to a decision is easy. It might not be to everyone's agreement, but it's easy. Mr Chair.
Ron Mark.
Thank you, Mr Chair. So I'd like the Minister please to take a call. I'd like the Minister to have a ponder on that and to consult, because I think we have a wee problem and you might end up with a stalemate. And one of the things that is very important, because I agree, New Zealand First agrees, amending the legislation so that the panel can report back in stages is very important. We all know, having, those of us who have done this sort of work in the past, you get a pile of submissions, you get some you can get submissions if you take Rodney, for example, land use, if you take the Central Auckland, housing, there will be issues that will be quite contentious. But at the end of the hearings on that topic, a number of drop-downs will be obvious. To wait until the entire hearing process is over before one reports back on that is maybe not the soundest idea, and that is why I'm assuming the government has really gutted out clause 144 of the primary legislation and trimmed it down, simply removing and deleting the words after it has finished hearing submissions in 144.1. So understand that. Understand that, the ability to hear the evidence, take the stuff that's immediate and obvious, make a recommendation, report it back there and then, timely, it's fresh in the mind, it's current, all good stuff. Understand that. But a problem if the quorum has dropped to 2 and people can't agree. So I think the Minister might want to have a think about that, and maybe have someone scratch out an SOP, or maybe change that idea and stick with the 3, because moving out the size of the panels from 7 to 10 is a good idea. Given the size of Auckland City, given the complexity of the problems that Auckland faces, given the varying views that will come before those select committees, you've got 5,000 submissions yet to be heard. Understand that having more people on the panel, having panels sitting concurrently, being able to appoint chairs to other panels which are sitting concurrently, understand all that. It's all about expediting. It's all about moving things forward quickly, timely, efficiently, without undermining the democratic process and without undermining people's rights to have a say. So I just asked them to have a look at that, please, and make a comment to us, give us some satisfaction that things will not be messy at that point. The Phil Twyford amendment would just signal at this point in time that we think it's a very good amendment. We think that the democratically elected representatives of the people of Auckland, this is a real simple point, should have a say in who the Minister for the Environment appoints onto that panel. It's really simple. This is about democracy. This is not about the government having people appointed to the independent panel that fit the government's agenda, the government's thinking, that are able to produce results, policies, decisions, directions that just coincidentally fit with the philosophical belief of the government of the day. Having said that, I have to put my hand up and say I was always surprised and grateful that the government selected me and appointed me to a couple of DHBs in my time that I was out of the House, reflecting that they were able to take on board people with differing views and differing philosophies, looking for that mix. We would hope that if this legislation goes unaltered from what is before us right now, that the government will make sure that those people who are appointed to that independent panel are not political lackeys. But we would prefer that the Phil Twyford amendment, SOP, goes forward to allow the people of Auckland, through their democratically elected representatives, to have the say in who is appointed to that board. It seems to me from some of the speakers before, and I refer to Chris Hipkins's comments, those of us down here in the Wellington Basin don't understand everything about Auckland. We know what we know through people that our own family who live up there, from what we read. I'm one of those lucky people. My partner is an Aucklander, and so I probably understand a heck of a lot more than I did before I met her. But I would not dare to stand up and say that I would be eminently qualified to sit on an independent panel looking at a unitary plan and say that I understood intimately and in detail the issues that were vexing the people of Auckland. So we'd come back to the Phil Twyford SOP, Mr. Chair, and say that we believe it's a good SOP. It is worthy of the government's worthy of government approval. Simple as that. Not consideration, worthy approval in the interests of enhancing democracy. Thank you, Mr. Chair.